Good evening, beloved. Welcome to Gorham United Methodist Church. We're humbled to know and to be in partnership with the historic Community Renewal Society. So humbled to have you all here for this candidates forum. It is so near and dear to my heart as a bivocational professional. I'm a pastor and I'm also a licensed attorney. And I used to get the joke, how can you be a lawyer and a preacher? Isn't one supposed to tell the truth and the other was supposed to lie? Ignorant, ignorant, ignorant. My dear sister will tell you that the role of the prophet is to advocate. And my dear brothers and sisters will tell you that that's the job of ours as well, as members of this great bar of the state of Illinois. Beloved, let us pray at this time. God, for your grace and your mercy towards us, we simply say thank you. Thank you for being so good and so kind. God, spark our awareness of your presence in this place. Allow your spirit to move ever so freely. Bless our moderator, bless our facilitator. God, bless the Community Renewal Society, bless Gorham United Methodist Church, bless the city of Chicago, the county of Cook, the state of Illinois, that we would be who you would have us to be. God, that we will do justice, that we will love mercy, and we will walk humbly before you as our Creator. Allow us to have an exceptional experience in here today. This is our prayer and our most humble supplication. Let us all say amen.
Thank you so much, Reverend Aaron. We're so appreciative of your hospitality, for opening your doors to us and making sure we feel welcome. I'm really excited to welcome you here. I am not discouraged by the number. We know in Chicago the weather, you either have the two types of Chicagoans, those that are like, oh, it's snow, or those who are like, I'm gonna bunker down. So thank you all for coming out and for being a part of this conversation. We certainly want to thank each of you for your commitment to being in community and to let us get to know you. So we are so honored that you accepted our invitation. And we're simply honored that each of you are here and taking our civic duty and responsibility seriously. We want to be, our theme for this year is to, we are the change that we hope to see, or for us to be the change that we hope to see. And so in order for us to do that, it begins by us honoring our commitment and our role in this beautiful process where we get to elect representatives that will represent us. I am Reverend Waltrina Middleton, and I serve as the Executive Director for Community Renewal Society. And I've been excited to be in this role for going on 7 months. And I look forward to being a partner in community with each of you. And I hope that even beyond today, that if there are ways that we can be supportive of your role and your works in community, that you will reach out to us. And we will also be, and Mina will share more, we have another forum tomorrow on the north side. And so please tell your friends that are out that way. We hope that you will join us there. And you can also visit our website at communityrenewalsociety.org to learn more about other outreach that we have in the community. So thank you again. Thank you for your welcome, Reverend Aaron, and welcome to this forum this evening.
Thank you, Dr. Middleton, and thank you, Reverend Aaron, for welcoming us into your sacred space. Good evening, and thank you all for coming. I know you braved the snow, so we're very happy that you're here. We're excited about this forum and hope that you will find it informative. Judicial elections are very important, and while we know the different candidates for president or the Congress, we don't know much about our judicial candidates, but we should, because local judges have a huge impact on our communities. They rule on cases involving child custody, alimony, landlord-tenant disputes, business conflicts. They also make decisions in our fundamental rights that often spark social change. So we hope you will enjoy getting to know these candidates and be ready to ask questions during the Q&A portion of the forum. If you haven't already filled out an index card, please raise your hand and one of the ushers will give you one, and then we'll collect it and read your questions during the Q&A portion. Tonight we had 13, but I think we're down to 9. I can't see, but I think we're down to 9 Cook County Circuit Court judicial candidates. So the way this is going to work, they'll have 1 minute and 30 seconds to respond to the question by the moderator. Alex, who's our timekeeper, he'll hold up the card to let you know the remaining time, 30 seconds, 10 seconds, and then stop. We want to give everyone equal time to respond, so please keep within your time limit. So before we begin the panel discussion, I'd like to introduce you to 2 of my colleagues who work with congregations on the South Side, Reverend Damon Smith, and Rishana Taylor. If you can just raise, they're in the audience. Please stop by and see them after the Q&A during the reception and just say hello. And now I'd like to introduce our moderator for the evening. Dr. Terry Solomon is an advocate, change agent, and visionary leader for social justice on behalf of African American children, families, and communities. Dr. Solomon wears many hats. She's the founding executive director of the African American Family Research Institute, adjunct professor at the University of Illinois at Chicago Jane Addams College of Social Work, accountability coach for Sisters of the Academy, and organizer for Chicago Regional Organizing for Anti-Racism. Dr. Solomon is dedicated to improving the quality of life of communities through family-centered public policy and racial equity programs. She has facilitated the creation of social policy impacting human services in the area of education, child welfare, and public health. She's coordinated anti-racism trainings and co-developed a racial equity assessment for child welfare professionals. Dr. Solomon received her Doctor of Philosophy, Master of Public Health, and Master of Social Work from the University of Illinois at Chicago. Please welcome Dr. Solomon.
Thank you. Good evening. Okay, now we're going to spend the next hour and a half together, so let's try this one more time. Good evening. I am happy to see everyone this evening and that you have decided to accept the invitation of the Community Renewal Society to share your platform as to why we should support you and vote for you as judges. So before we get started, I want you to just appreciate the people who are in the room. We have social workers. I'm joined by my colleague and some of his students from the Jane Addams College of Social Work. We also have members of the Chicago Association of Black Social Workers Political Action Committee, and I'm sure they want to talk with you. But we also are joined by members from the Community Renewal Society, their staff, and some of their members, and also the congregation here. So I just want to let you know that even though we don't have the audience that we want, but we got the influence that we need. So I'm going to ask this question for each of you, and I want you to first say your name and what area you are representing or running for. The first question is, what qualifies you to be a judge, and why should we vote for you? We can go in order.
Hi, good evening. My name is Perla Gerardo, and I'm running for the Judge Lacey vacancy in the 14th Sub-Circuit. And what qualifies me for being a judge and why you should vote for me is that I have approximately 15 years of experience. I started out interning at the Public Defender's Office while I was in law school. I interned at 26 in California in the felony division. And so as a law student, I was handling cases. I had my own caseload. I was able to do this under a special law license called a 711 law license. And after I graduated from DePaul here in Chicago, I was hired by the Public Defender's Offices where I also handled cases. I was assigned to the Domestic Violence Courthouse. I was there for approximately 2.5 years, but unfortunately, because of the county budget crisis, I was laid off, and so I then went into private practice. But I was very fortunate enough to have a lot of great mentors guide me along the way. And so currently, I work at a nonprofit called Beyond Legal Aid, formerly the Community Activism Law Alliance, where I handle all types of matters. I run a free legal clinic in the southwest side of Chicago, and I believe that all the experiences I have combined have made me a great candidate for judge that can understand the needs of the community, specifically people that may appear before me pro se. Thank you.
Good evening. My name is Judge James T. Derecho, Jr. I am a judge in the Circuit Court of Cook County. I was appointed by the Illinois Supreme Court in December of 2018, and I've been sitting since January of 2019. I have 34 years of practicing law experience. I am a member of Trinity United Church of Christ, and I bring that up because for several years at Trinity, I mentored the 4th and 5th grade boys every Wednesday during the school year. And for the last 12 years before I went on the bench, I was a member and a co-chair of the Trinity United Church of Christ Legal Clinic. So on the third Saturday of every month from 9 to 12, you'd find me at Trinity giving free legal advice to whoever walked in. In 2007, 9, 14, and 16, I received the Distinguished Service Award from the CVLS, Chicago Volunteer Lawyers, for my work with the Trinity Clinic. During my years of practice, I worked in a big firm, I worked in a big corporation, and for 25 years I had my own practice where I represented individuals and small businesses in all types of matters. During that, I represented a child social welfare agency, UCAN, which many of you may know, and I was their attorney, and I made new law in a case in which I represented them against AIG in an insurance coverage matter. The last thing I will say is, in 2018, I believe a Judge Coughlin was the first judge in 28 years not to be retained, and there was an effort to get him out. Everybody was watching, and the Supreme Court chose me to fill that vacancy. Punch number 187, Jim Derecho. Thank you.
Good evening, everyone. My name is Judge Kerry Maloney Layton. Thank you so much for having this forum. We appreciate the opportunity. Why am I qualified to be a judge? Well, I have been a judge for the past year. Like Judge Derecho, I was appointed by the Illinois Supreme Court. I've sat on the bench and presided over 100+ bench trials, contested hearings, and motions so far. Before I took the bench, I had 22 years of legal experience in public service. I bring that up, it's very important to me because it informs my perspective on sitting on the bench. Just a brief rundown of my background. I'm a graduate of Columbia University School of Law. I had 2 federal clerkships where I was inspired to become a judge by the people I worked for. I worked at the U.S. Department of Justice as a trial attorney, and then I moved on to Chicago, where I worked at Legal Assistance Foundation, which is now called Legal Aid Chicago, serving people in poverty. I also was an appellate attorney for 16.5 years. I got to argue 5 times in the Illinois Supreme Court in that capacity, and over 40 times in state and federal appellate courts. Off the bench, I'm very active in community service. I'm on the board of High Jump, which is devoted to advancing 7th or 8th graders who need an educational boost. I volunteered for Stand Up for Kids, and I'm active in other youth and education causes. That's the short version. I'll tell you more as we go on. But Judge Maloney Layton, Judge Maloney won't give you any baloney.
All right, good evening, everyone. My name is Judge Gerardo Tristan Jr., and I've also, like my colleagues here, have been on the bench for a year. I was appointed by the Supreme Court, sworn in on January 11th of 2019, and currently I'm in the First Municipal Traffic Division of the Cook County Circuit Court. Why am I qualified? Well, I have 17 years of experience. I was a prosecutor for about 15.5 of those years. As a prosecutor, my goal was always to do the right thing and to do justice. Prosecutorial discretion is a very important part of the criminal justice system, but it has to be handled right. You have to advocate, not only do you advocate for your witnesses, but you have to make sure that justice is being done in every case. So that was my philosophy as a prosecutor, and as a judge, my philosophy is also to do the right thing, make sure that you follow the law, but also understanding the people in the community. I come from Brighton Park. The 14th Sub-Circuit consists of those communities like Brighton Park, Pilsen, Little Village, University Village, Little Italy, further out here, Gage Park, West Englewood. And so I understand the people of these communities, and it is my wish to remain on the bench because I think that having done justice for the 17 years that I've been prosecuting and I've been a lawyer, I think that I can continue to do that as a judge. Thank you.
Good evening. I am Judge Deidre B. Walton, Cook County Circuit Court Judge for the 1st Sub-Circuit. I am filling the vacancy of the late Rhonda Crawford. I was appointed to the bench in June of 2019 on the unanimous vote of all the Supreme Court justices. Before becoming a judge, I was an attorney for over 22 years. The beginning of my practice was civil, where I did a lot of domestic relations, family matters, and some narcotics cases. The second phase of my career was in child protection, where I represented parents to regain custody of their children that were removed by Department of Children and Family Services. As an advocate for those parents, it did not always mean returning the parent home because it is about the best interest of the child. So some of the advocate work that I did was to make sure that the children were in relative placement instead of non-relative placement. The last phase of my career was in the criminal sector, starting out with misdemeanor and what I call normal felonies. In the last 9 years of my career, I was a criminal defense attorney in a unit called Homicide Task Force. So I represented only individuals charged with first-degree murder for 9 years. Since June of last year, I've been in the 1st Municipal Division down at the Daly Center in traffic and also eviction court. So I am from Inglewood. I grew up on 35th Street. Thank you. My punch number is 232. I'll tell you more as we move forward. Thank you.
Oh, I dropped something. Hi, everybody. I'm Kelly McCarthy, and thank you all for being here. I am a 18-year Cook County public defender, and the reason you should vote for me is about my whole life's history, not just my current job. So I like to talk about where I started, and if you talk about where somebody's been, you know where they're going. So I grew up on the northwest side of Chicago, and I come from a family that includes law enforcement officers. I obviously didn't go in that way. I was raised in a neighborhood and saw certain things, and when I decided to go to law school, I wanted to make a difference in my community. And it was a normal step I volunteered, just like you heard someone else say, at the Cook County Public Defender's Office at 26th Street, and I knew that was it for me. I wanted to be there. I wanted to be in the courtrooms, doing trials, helping people who are at the worst times in their lives. And I did that, and I'm really proud of the work I did with families. And the families that I still keep in touch with today warm my heart, calling me at the holidays, calling me when there's a birth in the family. And I think through my work there, it's always been important to me to have a good reputation, to work with integrity and honesty with all parties involved, whether it be victims, witnesses, my clients and their families, judges, state's attorneys. And I have been proud to have that respect from all sides, including the bench. And I say that because I have been encouraged by judges, state's attorneys, as well as my clients and their families and coworkers to run for judge for many, many years. And it wasn't until now that I have taken a step forward, thank you, and to run for judge and put myself out there. I never applied to be appointed judge by the Supreme Court, but I am running for the seat of Matthew Coughlin, a judge who I appeared before many, many times. And yes, he was unseated after a movement by mainly criminal defense attorneys to remove him as they felt he was racist. Oh, I am so sorry. But I'd be happy to speak with everybody after, so thank you, excuse me, for your time.
Good evening, everyone. My name is Felicia Simmons Stovall. I'm running for judge in the 2nd Judicial Sub-Circuit. I am an attorney. I've been practicing law for the last 23 years. I currently am an attorney with the Illinois Secretary of State, the Securities Department, where I prosecute cases involving financial fraud. Prior to that, I've also have been a pro bono attorney, largely for individuals who cannot afford an attorney, so to speak, but they do not qualify for legal aid. I practice in areas of evictions, landlord-tenant issues, family law issues, largely child custody and child support. I've also represented individuals in civil asset forfeiture, as well as contract or breach of contract cases. Why I'm qualified to be an attorney is largely because of my legal acumen, but also because of where I've come from. I was born and raised in Chicago, born in Robert Taylor Homes housing project. My parents then moved to West Englewood, and my experiences over life have really taught me and brought me to the place where I'm at today, learning and understanding the community that I desire to serve. Also having served as being a parent of a child with autism has given me an understanding of having to have great compassion. That, along with everything else I've said thus far, has what I feel have placed me in a very keen position to become and to serve as a candidate or as judge on the 2nd Judicial Subcircuit. Again, thank you so very much. Punch 232.
Good evening. My name is Deidre Bowman. I am running in the countywide vacancy of Colleen Sheehan. And I have been an attorney for over 27 years. And I too started out as a 7-Eleven in the public defender's office. At that time, however, they had a hiring freeze, and I had to work for a small firm doing constitutional law, First Amendment. I then, after that, went on and formed my own firm. I've had several partners over the years, but I've dedicated my career to representing people who have been harmed in the civil rights arena, employment discrimination, and personal injury. And I am qualified based on my years and years of experience, but also my understanding of what people go through. And I'm sure we could talk more about that, but I am very proud of the work I've done. One of my more well-known cases, the Borough Oak case. I was the first attorney to file in that matter. I was responsible for the appointment of a receiver and worked on that case for over 5 years, bringing $13.1 million into the estate and hopefully bringing some relief to the families. Deidre Bowman.
Good evening, everyone. Thank you for allowing us the opportunity to speak to you. My name is Chelsea R. Robinson, and I am running for judge in the 2nd Judicial Subcircuit. I have practiced law for over 23 years. I have done criminal and civil litigation, which includes murder cases down to misdemeanor battery cases. I've also done family law cases and taking those cases to trial if they have to be taken to trial. I've done personal injury. I've argued before the Illinois Supreme Court, the Illinois Appellate Court, and the 7th Circuit Court of Appeals. Not only that, I'm very active in my community. We want judges from the community and for the community. I am a member of the 5th District Pastoral Subcommittee, where I work with the pastors and the police to make sure that we can bridge that gap between the police and the community. I also hold annual expungement seminars in my church when my husband is the pastor of the Promised Land Missionary Baptist Church. I'm also the consultant for the Judge Mathis Show, but most importantly, I'm serving the people in the community every day, low-income and middle-income people who cannot afford attorneys. So keep me in mind on March 17th and vote Chelsea R. Robinson, punch 233. Thank you.
Good evening, everyone. My name is Krista D Butler. You'll see it on the ballot as Krista D Butler. My punch number is 231. By way of background, I am what's considered a public interest attorney. And what that means is that I've spent the entirety of my career as an attorney advocating for and championing the causes of persons or groups of people who have been minimized, marginalized, and oftentimes overlooked for reasons which should not make sense to anyone within the sound of my voice. Reasons such as marital status of parents, receipt of public entitlements which are allocated for those persons. I've done the work in this area because I feel that abused and neglected children, elderly people, persons who suffer from mental illness, and other persons with disabilities are the most in need of services that an attorney can afford and are least likely to be able to access that delivery system. I think that that background dovetails very nicely with the issues that are in our community. Our community's concerns are social justice. I think that my background by way of social work creates an opportunity where I understand the issues that need to be addressed, and I'm in a position to make tough decisions in order to ensure that the members of our community are treated justly and fairly. On March 17, 2020, I ask that you punch 231 and elect Krista D Butler, Justice and Fairness for All. Thank you so much.
Good evening. I am Wendy Deloach, punch 244. I'm on the ballot, 244. I'm running for the vacancy of Kevin Sheehan, different from Ms. Bowman, who's running for another Sheehan. I am here and running for a judge because May 1990, I was licensed to practice law, and on that day, my brother was arrested and charged with 16 felonies that he did not commit. When the police had him at the station, they said, if you just tell us that you did it, we will let you go. My brother called me from the police station and said, why don't I just tell them that I did it so that they will let me go? You see, torture is not just physical, it is also mental. Today, my brother is a well-known comedian, Reggie Reg. He does the impersonations of Denzel Washington and many others. You can find him on YouTube, HBO. I have been a lawyer for 29 years now. I'm licensed here in Illinois. I am a Chicago native, and I want you to vote for me because I will bring fairness to the bench. I will bring balance, wisdom, and I will never forget how they arrested my brother for something that he did not do. Thank you.
So, I will ask, I have several questions to ask, but the sad part about this is that each of you would not be able to respond. So I will ask a panel of 3 to respond to the questions that I have. And I want to start off, you know, at the national level, we're hearing a lot about judges, sentencing laws, and recognizing that everyone do not receive the same type of treatment. And so what criteria, I'm going to start in order, the first 3, what criteria would you use for deciding whether to impose or affirm sentences outside of standard ranges or the sentencing guidelines?
Okay. Can you repeat that last part?
What criteria would you use for deciding whether to impose or affirm sentences outside of standard ranges or the sentencing guidelines?
Okay. Well, when someone is found guilty of a crime, they obviously do a pre-sentence investigation where they do a social history of the person to find out what's in their background. I just want to give a little bit of background. I used to work at Mercy Home for Boys and Girls, where we worked with children that were considered at risk. And so I think that whenever a judge is going to impose a sentence, they should be relying on that pre-sentence investigation, and they should ensure that every aspect of that person's life has been looked at, because I do think that a lot of times what happened to someone when they were younger has an impact as to who they are as an adult. And so that's the first thing that I would look for. And of course, I would have to be fair and impartial. I wouldn't be able to, use my personal bias, but I would look at that pre-sentence investigation to know if, first and foremost, there is a way to rehabilitate that person as well, and that if a sentence does need to be imposed, judges can also recommend that someone be, put in a certain division to address certain needs. So I would first and foremost look to see what specific needs a person has, and then go from there to determine whether there should be a lengthier sentence imposed, but also respecting the victim as well, and what the wishes of the victim as well. So it's really a difficult question to answer, because I do think that there's so many things that have to be considered, and it has to be considered on a case-by-case basis.
Okay, thank you. And I am going to put some time limits, because I see we're not going to be able to get to everyone. And so I am going to ask that you be very succinct. And what do you want to give? 30 seconds to respond?
60.
How many? We're going to give you about 40. Not seconds. 40 seconds to respond. I want you to be succinct, because you have thought about this question.
Okay.
This is not a new question for you.
Well, I'll be very succinct. My background is 100% civil. So I practice in the civil courtroom, so I have very limited civil experience. Criminal experience. But I will say this. One of the things that is very important is the concept of procedural fairness. And procedural fairness, which is taught to judges actually, basically says if you treat people with dignity and respect and explain to them why you're doing what you're doing, you will have a much more favorable, they will receive it a much more favorably. So if I were in a position to sentence someone, I would make it clear to them exactly why I'm doing what I'm doing, and how that fits within the confines of the law, so that hopefully they walk out of the room feeling, I'm not happy about his decision, but I understand and I feel treated fairly.
Thank you.
Okay, so to be very succinct, I did sit in traffic court when I first got on the bench, which is a form we consider criminal misdemeanor charges, and had to sentence people. There are reports that will be supplied to the judge that go into every aspect of a person's background. Now, this is why it's so important to put caring, concerned individuals on the bench, because as judges, we have a broad range of discretion. And the question is about when to go outside the statutory guidelines. So the answer is you should consider everything about a person's background and weigh that against whatever it is they did, but understanding their background. So I see my stop time, so I can't elaborate.
Okay. So with that in mind, what are your views on whether the court as a whole deals effectively with racial and gender bias?
I'm sorry, what?
What are your views on whether the court as a whole deals effectively with racial and gender bias?
Well, now as a judge, Judge Evans here in the Circuit Court has put in some very good courses, and actually not just Judge Evans, but the whole Illinois Supreme Court in terms of training. They train us on implicit bias to recognize the biases that we all have, even if we are a minority, even if we are, me as a Mexican American, I have my own biases. I have to acknowledge them. I have to recognize them so that I can be a fair judge, and that anybody coming before me will understand that I've recognized that, and that, so I can do justice, in other words. So I do think that it's changing. Practicing for as long as I have, I don't think it was done very well in the past, but I think that there is a new day, and hopefully with the new crop of judges that will be more effective.
Okay, thank you.
Same question.
Same question.
Well, the implicit and explicit biases are there. They're just there. Judges are people, so biases that exist in our normal life exist on the bench. What the court has done to try to make things better in terms of dealing with race issues and gender issues is the court is finally becoming more diversified. As people of color, overall, we are 6%. It's not a great number. We are only 6% on the bench across the world. And as black women, we are now 2%, up from 1%. So the court has started to move in the direction of diversifying our courts. So I think that's the key to resolving those issues, greater diversity.
Same question?
Same question.
I'm probably going to echo a lot of what I've heard, but coming through the system as a public defender, as somebody who represented people on immigration matters, child abuse, child protection matters, and coming through 26th Street in the most serious felony matters, and being a manager now and training new attorneys coming in, there is an influx now of training across the Cook County-wide offices for implicit bias training. So people are just now starting to examine the biases and getting a certain type of training. And I'm glad to hear that Judge Evans is doing it with the judges as well. And I do agree that I think over time we're going to see an improvement. But I think as an attorney, I have been one to have those conversations with the judge. Maybe a judge doesn't realize how they just sounded. Maybe another attorney doesn't realize how they just impacted somebody. So we all have to have a voice, and we have to talk about these things. So that's how it changes.
So my next question is for the next three candidates. What factors are considered in granting and setting bail amounts for defendants? What do you believe is the primary consideration?
Okay, so I'll say that I'm primarily practice in civil law, so I don't do criminal law. However, the experience that I have had with criminal law, when looking, and the most important, let me start by saying the most important issues that should be taken into consideration when you're setting bail is to whether or not that person would appear again before the judge, whether or not that person will flee the jurisdiction of the court. That should be the primary purpose of a bail amount, and not the person's ability or lack thereof. When a bail amount is set, and sometimes it's set excessively, an individual is not able to afford bail, and they should not remain in custody because of their inability to pay bail. What you have to look at is the factors of whether or not that person will flee the justice system.
I would agree with that, and I'm a strong proponent of the reforms that we're seeing now. There have been way too many people taken into custody and who have remained in custody because they haven't been able to pay their bond. That is not acceptable. As everyone knows, a defendant is presumed innocent, so they're innocent, and unless there is a good reason for keeping them in custody, such as a failure to appear or like high likelihood of danger for one reason or another.
I do practice criminal law. And the things that the judge can consider, of course, as stated, whether or not the person will appear back in court, but also they look at the background of the defendant and whether that defendant is a danger to society. And a lot of times, even when my clients have low backgrounds or very small or no backgrounds, the bail that they receive are bails that they cannot afford. So it's been unjust for people with low income who are living check by check to be able to afford the bail. And I am glad that we have put in bail reform where the bails have become lower, where a lot more people are getting I bonds and smaller bonds.
Okay. So, I've heard the responses, and some of these responses just ain't sitting right with me, okay? And so my two candidates, because we hear the legal understanding and what the law says, but we know the practice is not necessarily there. And I want to know, what are you going to do to change the practice? Because yes, we have guidelines regarding bail, we have guidelines regarding sentencing, but we've seen, particularly in Chicago over the past year or two, where sentencing guidelines don't apply evenly to people. And so yes, you know, you have those guidelines. So what are you going to do differently, or what can be done differently to really look at the practical issue of how these sentencing guidelines are not applied evenly to people who are brown and black?
So you touch on a very interesting point, and I think all of my colleagues have shared some of their concerns. The bottom line to address your inquiry is we need to elect judges who have the courage to change and challenge what is. Zip codes at this present time are determining who gets what. So a 15-year-old in Oaklawn will get a different sentence than a 15-year-old in Inglewood. That should not be the case, but sadly it is. We need to elect judges who understand and who have respect for our communities, who understand that Black lives matter, brown lives matter, and just because you are of a certain pedigree does not exempt you from the laws of the state of Illinois. And so I think that diversity has to be reflected on the bench in order to get to the respect that our communities deserve.
I'm going to speak to creativity. I've been fortunate enough to have experience in 2 states. I had a case recently where my client was looking at 48 years. He received 8. But that's because I realized that the judge needed information from me, and I gave him that information. So I don't know what all the other criminal defense attorneys are doing, but I know as a judge, I'll be listening for some of those creative alternatives. I submitted my client to a psych eval from an expert that the state prosecutor's office uses all the time. And that individual had credibility with the court system, and I spoke about that during the sentencing. I would be listening for that. This was an expert who said my client was not a risk to society, but he was charged with a horrible crime, but he wasn't at risk. It was an isolated incident, and sometimes we need to bring to the judges some creativity, and I will be listening out for that. Thank you.
Thank you. So this is a question for each one of you. Do you ever wake up in the middle of the night thinking about a case, wishing you had handled something differently? If so, please describe one situation. Okay. It's open, however way you want to flow with this particular question is okay.
All right. I guess I'll go first. All right. Absolutely. I had a very intriguing case as a judge. A young lady bought a car, a used car. Within 2 days, the car broke down and it was no good. And she bought it as is. And the law in Illinois basically, now they have a new law that says it's no longer as is. If it's over if it's, for example, the first 500 miles in the first 15 days, it doesn't sound like much, but it's better than nothing. If the car breaks down, you're good. But it has to have less than 150,000 miles on it, or it doesn't qualify for this law. But there's also, I have to stop, but anyway, I agonized over it. I did. I lost sleep over it. I worked it. I researched it to try to get it right. But in any event, I got to stop, so I'll maybe continue later. Okay.
There are certainly cases where, since I'm a fact finder, you wonder, did I do justice? Did I consider all the factors? And part of it is a lawyer's job, as my candidate Deloach was saying, to present you with the facts. But colleagues on the bench have reversed themselves. Now, when I was in traffic court, I had a colleague who said, you know what, I thought about this overnight and I changed my mind and actually did change her own decision. I think you have to have the courage to say, I made a mistake. I didn't do it right the first time. We're human. We need the facts presented to us, but we also have to be able to say, I'm going to do this differently. And that's what I'm willing to do.
Yes, I mean, even as a judge now, I've only been practicing for a year, but I think a lot of the cases that that we look at, I mean, I agonize over the fact whether I did the right thing or not, because it's one thing as a person to say, of course that person was drunk. I mean, yes, they were drunk and they were driving, but if the state doesn't properly present a case, I can't rule in the state's favor. I can't find that person guilty because I have to follow the law. And you know, the same way, if a defendant has an excuse, I've got to consider that excuse. But again, you know, is it the right thing to do because they were driving somebody to the hospital? Well, of course, yeah. Then you think about that. The law says you shouldn't, but you know, the circumstances are different. So you do agonize about it and you do think about it. But again, you try and do the right thing.
Well, both as an attorney and as a judge, I have agonized over cases. Having been a murder defense attorney for the last 10 years of my practice, of course, each case, every night, I'm like, should I have called that witness or allowed that person to speak or allowed my client to testify? But there's a toss-up. You can put them on, they can hurt the case more than help the case. And as a judge, there are decisions that are very hard, specifically in eviction court, when I have to, you know, evict a 70-year-old. That's difficult for me. But if the law says that that's what I have to do and that individual has not paid rent or they've entered into some agreement, I have to follow their agreement. So, yes. But in that instance, we just have to pray and keep trying the best that we can to be just.
So I would say, of course. And it's not just one case, it's many. In my career, I've tried over 60 jury trials and many more bench trials. And what we talk about as public defenders is you're never off the clock. I keep a legal pad next to my bed at night, and I would routinely wake up in the middle of the night with an idea for a case, an investigation that had to be done, a question I didn't ask at the trial the day before. And what I tell the attorneys I train is that if you're not having those thoughts, there's a problem, because you're dealing with people's lives, and we are many times the one person somebody has in their life to fight for them with something that may affect the freedom they have for the rest of their lives. So we will always question and we will always look back to make sure we did the right thing, and I know I do that. So that would be my answer.
So I think that the case that probably I lost some sleep over was a case involving a child being removed from a home. The mother had a new job and she went to another state without asking permission of the court. In that particular case, had to file a motion to reconsider for the judge who, and still in my opinion today, wrongfully removed the child. My sleep that I lost on that case is wishing that I had stepped in a little earlier. It was a case that I had taken pro bono, and it was a former client of mine, and it asked me at that time if I could step in. And I did not have the capacity to step in at that earlier. So I lost sleep over it because I said, well, maybe if I had pushed some other things aside, that I could have stepped in and helped her sooner, but we did get the child back.
This is an issue that I think a lot about in terms of cases. A client of mine called Veronica is her name, and she was ultimately convicted of armed robbery. She was a friend, she was a colleague, and I couldn't help her, and I saw that as we were going along. Ultimately, I did help. She was facing a mandatory 21 years, and I did get that reduced to 8 years, but boy, I lost a lot of sleep.
I can agree with my colleagues. It's been being a criminal defense attorney. There's many cases that I agonize about. I normally agonize before trial, just I wouldn't say agonize, but just making sure that I'm able to cross every T, dot every I, like you said, get up in the middle of the night, dream about the case. There have been cases that have said, could I've done more, should I've done this? And those type of cases I have in one opportunity, had opportunity to do the motion to reconsider, where the judge did reconsider his ruling and then reduced. My client, again, felt like that was not enough. I agonized a little bit more, and we took it to appeal, and it was reversed. Thank you.
So part of my responsibilities in my current position is I'm an administrative law judge, and many of the cases that I hear involve medically fragile, technologically dependent children. Oftentimes, these matters come before me for review, and what has to happen with them is I have to make a determination in terms of whether or not the services that are put in place are going to stay in place. I have parents who are agonizing over the support that they get from these services, but there are clear-cut rules in terms of whether or not they should continue to receive the services. Part of the social worker in me always wants to step out of my role as an impartial decision maker and say, well, why can't you just offer this, or can't you give her that? Or my background with regard to abuse and neglect makes me wonder what, if anything, will happen to these children. So I agonize over those sorts of decisions. Thank you.
2 cases I agonize over. One involving the Alford plea, which is a United States case in which a defendant had to take the deal, because if he lost, he would have lost his life. The Alford plea. That's where you have to plea because there's nothing that you can do with regard to defense. The second one are the ones that I want to try and the client doesn't want to try. Okay, the client wants to go to trial, and I'm trying to sell the client on going to trial. But I always have to remember, I'm not the one that's going to suffer the consequences. So when they want to go to trial, I take them to trial. When they don't want to go to trial, I don't take them to trial. But it's a problem when it's the Alford plea situation, and they have nothing, and they have to take a deal in order to save their lives.
The type of case that I lose sleep over is really kind of a similar fact scenario where I also work in immigration and I do criminal defense. So there's this area called crimmigration where depending on what happens in a criminal case has an effect on your immigration case. And so the kinds of cases that I lose sleep over are when my client wants to plead guilty on the domestic battery case just so that he doesn't have to sit in jail anymore, but then it's going to have an adverse effect on his immigration status where he or she could potentially be deported. So those are the cases that cause me to lose sleep because there really is no way, as others have said, it's really what the client wants to do, and no matter how much you try and convince them or tell them about the consequences, if that's what they want to do, there's not much you can do.
Okay, let me see. Do we have any questions from the audience?
Before we go to the audience, I just want to introduce Taria Givens, our communications director. We're going to take a little bit of a pause from the panel discussion, and I can't see her, but she's just going to talk for a few minutes, and then we'll go to the Q&A portion.
Okay. Before she speaks, I want to put one issue out here. One is that, and you can tell me this is an urban myth, that if a defendant decides that he wants a jury trial, he is at risk of receiving more time. You can tell me that's an urban myth, okay? The other thing is that I think in the history of Cook County, there may have been only 3 or 4 defendants who served as their own judge, own attorney. And there was one case where this person received like 120 years. And this was a person who was known to have a special ed issue IEP and did not have the mental capacity to make an informed decision. And I know these cases are probably, some of these cases happen all the time before you, but can each of you, as my communication person come up, give me about 30 seconds response as to the urban myth and the issue about people who do not have a mental capacity to serve as their own attorney, but they are allowed to do it, and then they get these sentences that are out the box. And whoever wants to volunteer to respond, please feel free to do so. I'm going to give you my mic, and then you take that mic.
Okay. One of the pieces of advice that several public defenders gave me when I first started interning at the public defender's office was they said, be prepared to be the most unpopular person in the courtroom. And why is that? Because you're the one that's going to insist on going to trial when everyone just wants to go home. And so I don't necessarily think that it's an urban myth, because I have seen it both when I was interning as a law student and in private practice, that you are the unpopular one because you are the one that wants to go to trial and pretty much give your client their day in court.
I'll let the criminal people answer that, because they'll give you a much more effective answer.
When I sat in traffic courts and people wanted to go to trial, I would never sentence them more than what was going to be the sentence that they were, was the offer that was being offered. I don't think that that's right. As to whether it's an urban myth, when you go to a jury trial in a criminal courtroom, I haven't sat in criminal court, so I let someone else answer that question. But it really is important, like, who's sitting on the bench. I think every courtroom is different, and you want to look for people that have hearts and community service in their background so that they don't make bad decisions.
Yeah, so I practiced for about 10 years in the felony trial division as a prosecutor in Cook County, and there is a jury tax. There are some judges who do impose that jury tax. You shouldn't go to trial with that judge because that judge is going to give you a higher sentence than whatever was being negotiated beforehand. And so it's not an urban myth. It does exist, but that's why it's our responsibility as judges to eliminate that. You cannot do that. You cannot have a person. It's their constitutional right to have a jury trial. You have to give them that right. You may have to be there another day or two, than the 15-minute plea, but it's their it's their right to do it, so you shouldn't tax it.
Hi again. I somewhat disagree. Jury tax, if there's a judge on the bench who has decided that they don't want to do a trial, they don't want to do a trial at all. Jury, bench, any kind of trial. And if they're going to be a hard sentencer, that person's going to be a hard sentencer regardless of the type of trial that it is. So jury tax is a myth, but some judges do follow that. As far as the mental health issue, if a judge recognizes that a pro se litigant has a mental health issue, they're supposed to initiate the process and order that person to do an examination before proceeding to trial.
I was going to talk about that a little bit. So there's an examination that a client will have if I have a client who is mentally ill or maybe can't read or write and is asking to represent themselves. The judge can order an examination where experts will evaluate the client to see if, in their opinion, can they represent themselves. And from that point on, it goes further. I've had cases both ways where I think they shouldn't have been allowed to, in cases they should be allowed to, because I think it's their right if they would like to do that. So there is a process in place should it be followed. There is also, that is always the danger. Some judges I have seen be rather, and not have a whole lot of patience listening to a pro se, what we call pro se litigant. But there is something called a jury tax. I've had judges say, well, someone's accepting responsibility, so the number before and the number after is going to be different. So it's what you call it. There's different factors in every case, but that is a discussion we have with our clients before going to trial, definitely, and it shouldn't be. And I've had to fight as a public defender for 18 years to say, yes, I'm going to talk a little longer. Yes, I'm going to keep us here, because you know what? It's my client's life. And that's what we do. And so we stand up and we fight, and that's the way it should be. We shouldn't have to fight for these things. It should be a given. So thank you. And sorry, I kept talking when I shouldn't.
Hillstar County, yeah, I'm laughing. So it's not a myth, and I'm actually assisting a family member was convicted of discharging a firearm or actually shooting someone in an attempted murder case. He decided to go to trial, and at this particular time, the individual, no criminal background or no violent criminal background, I believe he had been arrested for marijuana possession, but got 34 years shooting someone in the leg. And this is someone who's black, and the judge was black. And so it's not a myth. That's something that actually happened, and something that I'm attempting to assist the family with.
Yeah, I'll echo that. It's not a myth. There is definitely a jury tax, and it's wrong. In terms of the mental health issue, it is the obligation of the court. It would be my obligation as the judge to make sure that the defendant is mentally able to be his or her own attorney, period. And it's not something I, as a judge, can just look away or ignore or pretend it's not their obligation.
In regards to getting more time for jury, that is not a myth. There is a jury tax. I've heard it from multiple attorneys. I've seen it, and it's outright wrong, as stated earlier by some of the other panelists. It's discouraging our people from actually having a jury trial. We have clients, as had stated earlier, who are afraid to go to jury trial because they're, I'm gonna get more time, but yet and still they're saying that they're innocent. So they should have a right to a jury trial. So it's not a myth. And quickly, in regard to the mental health, it's the obligation of the judge to make sure that that person is mentally capable of representing him or herself.
So I'll preface my comments by saying that I am a civil practitioner. I've had limited experience in the criminal arena other than working in penal facilities, which prompted me to go to law school. I will say that a distinction should be drawn between clinical fitness and legal fitness. So under the scenario that you posed, I believe that the judge and the attorneys would have to ensure that the person gets a fitness evaluation. If they receive that evaluation, under your scenario, they would have to receive that evaluation. I think that just in order to protect all of the parties in the courtroom, what would happen is the judge would appoint a co-chair for that person to ensure that they know what they're doing, and so that nothing that's decided in the court could be reversed.
You know, I'm going to kind of agree with Tyria Walton on this one. What I believe happens when you go to trial as opposed to taking the deal is that what our clients don't understand is when you take a plea, there are certain counts that are taken off the table. You see? So I don't know how this is being explained when you hear about it, but if there's 16 counts and we're down to 1, the sentence will be lesser. But when they go to trial, you're going to go to trial on all the counts. And that's how I think the sentences are sometimes heightened. That's what I believe in a practical sense. It feels like a tax, feels like a myth, but in a practical sense, I think that's what really happens. Otherwise, I haven't really experienced this so-called jury tax.
Good evening, everyone. Wasn't this informative? I mean, it is our hope that you learn something new about the candidates, where you feel empowered when you go to cast your vote next month. You have some now information and education that you didn't have prior to tonight. You know, we host a lot of these events on a myriad of subjects just to empower you, the community, so that you can be informed. It's always our goal to educate you guys, and tonight I just want to appeal to you to partner with us at Community Renewal Society and consider making a donation so that we can continue to host events like this on all kinds of subjects to involve you and empower you, as I said. Some of you may have gotten an envelope just like this. If you haven't, I have plenty of them at the back. It's just where you can make a donation, and we really appreciate a one-time donation if you want to give one tonight. But I appeal to you to consider being a monthly donor. It's very easy to do. The information are on here. That way we have consistent funding, and we can just bring more and more events to your community, just like tonight. Wasn't the panel great? Wasn't this some great information? Amen. Right before the vote next week. So I just want to ask you to do that. You can see me if you want to make a personal donation today there, or you can also go to our website, communityrenewalsociety.org, and you can make donations there.
All right, we do actually have a few questions from the audience. So, yeah, thank you. So we have quite a few questions, but we don't really have the time for it. So we have about 20 minutes left, and so we'll get to as many as we can. Maybe not ask all questions to all the candidates.
Yes. Okay, one question apiece. And of course, how many seconds? Whatever I want. How many?
20 minutes left.
20 minutes left. Okay, you still get 40 seconds, okay? How can we work towards a more just sentencing and care for juveniles? What restorative justice approaches can judges explore for youth? So I know the question is focused on our juveniles, but there are some restorative issues that we can look at for adults as well. And so, anyone want to volunteer to take this question? Okay then, yes.
Juveniles already have some advantage in that whatever their sentences are, they're usually over on their 21st birthday. They can start again. And so some of the second chance sentencing are available to our juveniles. Like in the traffic division, anybody who appears before me who's under 25, I automatically give them deferred prosecution where they can do community service in lieu of any fine or punishment that I normally issue on a ticket. So the statute does allow for us to give second chance sentencing. So I always try to extend that to our juveniles. But they are blessed in that on their 21st birthday, they can start again.
I just want to add that there are restorative justice court. There's a special court. Several special courts that have been created. So, and I don't know a lot about it, so I just wanted to add that really quickly. But there are new initiatives. Mental health court and restorative justice court is one of them. There are exciting new initiatives that we need more.
For adults and juveniles.
I don't know if the juveniles are included. That's why I just want to mention it. I don't know a lot about it yet. So.
Okay. So, do you believe prosecutors have power over judges in plea deals being allowed? Do you believe prosecutors have power over judges in plea deals being allowed?
I mean, I was a prosecutor, and I think I understand the question. One of the things is prosecutors have discretion. A prosecutor can take a murder case, walk into court, and dismiss it. The judge cannot. Unless there's some technicality and the defense makes a motion, then the judge can dismiss it. Otherwise, it's up to the prosecutor to determine. Whether they hold, I don't think that they hold any power over the judge, but prosecutors have to resolve cases as well. They should look at their cases. They should look at the defendant. What is the defendant's background? What did the defendant do in this case? And then act appropriately, because you can't have one consistent way of prosecuting every retail theft, every murder, every attempt murder, every armed robbery. You have to look at each case in a case-by-case basis.
There's, whenever someone is charged with a crime, there's what they call a 402 conference, where the defense attorney can approach the state and say, can we conference this with the judge? However, if the state's attorney does not agree to the 402 conference, then you're not really able to plea your case to the judge. And so the reason why we would be asking for a 402 conference is to be able to present to the judge mitigation that might otherwise not come out if the case were to go to trial. So I'd say that in that regard, they do have some control as to whether you are able to bring other information to the judge that otherwise would not be available at trial.
Okay, so I have a question about that, but I'm going to stay on point. What's the difference between the Cook County Circuit and sub-circuit courts?
I'm happy to.
Okay.
What is the difference between Cook County and sub-circuit courts?
Everyone hear that? The difference between first of all, whether you are elected in the sub-circuit or in a countywide vacancy, you are a full judge with all the powers of one another, co-equal. The sub-circuits were created because there were certain groups of people who could not be elected. For example, I'm Jewish. Jews could not be elected countywide. African Americans could not be elected countywide, and so forth. So the county is divided into 14 sub-circuits, as well as having a number of countywide vacancies. Oh, yes. So, but everyone is equal. It has to do with the geographical area from which the judge is running or the candidate is running, and from which you're voting. So everyone here, if you are a registered voter in Cook County, will see the slate of, I think, 13 full circuit countywide judges, and then depending on what sub-circuit you live in, you will have the sub-circuit judges as well. Everyone does the same thing.
Okay.
So just correction is 15 sub-circuits. No,
Okay.
no problem.
So you mentioned, was that the 402 conference? And so I have a question. This is not my question. Please explain what you think the issues are in the Jessie Smollett case, because there was a 402 conference. And if you're saying this is too hot to handle, I understand. Well, the judges can't answer it, but the candidates. Okay. They can't either. Issues, but not the case. Are you talking about the recent indictment or the issues are not the case?
Well, in general.
In
yeah,
general.
No.
Well, I'm just really talking about, okay, I'm not even talking about that case. So I want to know, why is it that the 402 is not equally applied? Because I know this happens all the time for people of different communities, different classes, different ethnicity, different races. Why is it is not equally applied? And when it is applied, there's an uproar. Can somebody explain? Just help me understand that.
I will answer that in a very general way, because I think something that's very important, a point I'd like to make. During my practice, I handled employment discrimination cases. And being me, I did the homework to find out what is the history of employment discrimination cases in the federal court. And what you found out is, if you're African American and you bring an employment discrimination case in the federal court, you have a 90% chance of losing. And if you are a woman bringing a gender case, you have a 70% chance of winning, of losing. And if you bring an age discrimination case, it's 50-50. And in examining those statistics, I realized, why does the age case have a better shot? Because most of the judges are old. And they felt discriminated against. So what that taught me, and to answer your question about people being treated differently, that is why diversity on the court is so important. I mean, for example, I'm the second oldest of 13 kids. I grew up in Gary, Indiana. My dad worked in a steel mill. And you know what that taught me? For example, my parents had struggles along the way. They weren't bad people, they just had struggles. So when people appear before me on credit card cases, because that's a lot of the cases I hear, I have a totally different perspective because I have a totally different background. And someone else may think, why don't they just pay their bills? So the answer to your question is diversity. The answer is diversity. People bring their life, they tell jurors in jury instructions, don't leave your life experiences out on the street. Don't leave your common sense on the street. Judges are no different. They bring those exact experiences to the courtroom. Hence, that is why diversity is so important.
Okay. So, that's it, hand.
So, having been a criminal defense attorney for a very long time and a resident in communities such as Inglewood, I think I can tell you why the 402s are not the same everywhere. And it's in general because I'm not going to skate around race because it's real. Justice doesn't always look the same on the south side when you compare it to the north side. The west side doesn't look like the east side and so forth. So the 402 conference is based on the agreement between the defense attorney and the prosecutor. If the prosecutor does not agree for whatever reason, there is no 402. So if they just don't agree because they're not interested or vested in the life of the accused or the defendant, or interested in trying to see if there's a way to resolve the case, there will be no 402. But if that compassion exists in that prosecutor, then there will be an interest in making sure that, let's see if we can do something that's a lesser sentence.
I just wanted to add something. There's been comments made about diversity on the bench, which is absolutely important. I've seen my clients and their families feel not represented, but go in front of a judge that looks like them. There's a hope, there's a feeling. But I want to say, as my experience as a criminal defense attorney, we need to not just look at the color of somebody's skin. We need to look at their credentials, what they've done with their career, and what they will do on the bench. I have been in front of some judges of color that were harder on my clients than any white judge ever was. So forums like this, I think, are so important for that reason. So let's not discount people for whatever the color of their skin is, and look at everybody's credentials equally. Thank you.
Okay, so for the next, we have about 7 minutes left. And so each time you respond, well, I want everyone to give your last name and your punch number. I want to do that right now while we have time. And your punch number as it appears, your name, as last name as it appears, well, no, your full name as it appears on the ballot, okay, because there may be many individuals with the same last name.
Last name is Gerardo, and it's 234.
It's James T. Derecho Jr., that's D-E-R-I-C-O, Derecho like Jericho with a D, and it's 187.
Judge Kerry, Maloney, Layton. I say vote for Judge Maloney. You won't get any baloney. And vote for me, punch 183.
All right, mine appears as Gerardo Tristan Jr. It's punch 231. I'm in the 14th sub-circuit. However, it's a different vacancy from Ms. Tirado. Ms. Tirado is running for the Lacey vacancy. I'm running for the Bertucci vacancy, so you can vote for both of us.
I am Tira B. Walton, W-A-L-T-O-N. My punch number is 232. My vacancy is the Crawford vacancy. There are 2 first sub-circuit seats. Crawford vacancy, Walton 232.
It's Kelly Marie McCarthy. It's the Coghlan vacancy. It's the 2nd countywide race. I'm the first on the ballot, and it's punch number 184. Thank you.
And I am Felicia Simmons Stovall. I'm running in the 2nd Judicial Sub-Circuit. My punch number is 232. And as you hear people say, bye, Felicia, I need you to say, hi, Felicia, punch 232.
Deidre Bowman, running in the countywide Colleen Sheehan vacancy. I will be the first name that appears in that vacancy, number 219.
My name is Chelsea R. Robinson, and I'm running in the 2nd Judicial Sub-Circuit, and my punch number is 233.
My name is Krista D Butler, Krista with a K, Butler common spelling. I am a candidate for judge in the 1st Judicial Sub-Circuit, running in the Rodney Hughes Brooks vacancy. My punch number is 231.
My punch number is 224. 2 plus 2 is 4. I'm the only Wendelin on the ballot. I'm the only Wendy on the ballot. And I'm the only Deloach on the ballot running for the Kevin Sheehan vacancy.
I will ask each of you this question, and it's a yes or no response. And I want you again to say your number only and say yes or no. Do you favor minimum guidelines, minimum sentencing guidelines? Punch number?
Punch number 234, no.
I'm punch number 187. Not sure I can answer that. Sitting
Okay.
judges, yeah.
Yes or
I
no?
don't- So I can't answer that. I can give
Okay.
you I don't think I can answer that.
Okay.
Yes, sorry.
No.
I forgot to mention my vacancy. It's Carol Bellows. Neither of my opponents are here, so I'm the only one here in that race. Punch number 183, and minimum sentencing guidelines. I like judges to have discretion.
Yeah, punch 231 for the Bertucci vacancy in the 14th sub-circuit. And yeah, I mean, as far as the answer, whether it's yes or no, judicial discretion, I think, is important.
Tira Walton, 232, Crawford vacancy. I'll be the only one there. I'm unopposed, thank God. And I, too, will only say that judicial discretion is appropriate.
McCarthy in 184. I would say also judicial discretion is important. I see arguments on both sides, but it comes down to who your judges are. And that's why looking at us all individually is important. I'll echo that again, because discretion is great, but if you have someone who's abusing it, it's not so great. So I don't think there's an easy answer either way, but it comes down to the quality of the people sitting on the bench.
Simmons, Stovall, punch 232 in second sub-circuit, and I believe that judicial discretion is necessary.
Deidre Bowman, 219. I do not favor mandatory anything, discretion.
Chelsea Robinson, punch 233, judicial discretion. And that's why we need fair judges on the bench, so we can have fair, compassionate discretion.
Krista D Butler, punch number 231, First Judicial Sub-Circuit. I, too, believe in judicial discretion. I think that all matters that come before a judge should be evaluated on a case-by-case basis, and there should be a consideration of the totality of the circumstances.
Wendy Deloach, punch number 224, and I believe in discretion as well. We just had a long discussion about 402 conferences and mitigation. All that information has to be input before you can make a decision. And you want to look for a reason to keep the sentence minimum.
All right, I think we're going to have to conclude there. Dr. Middleton, if you'd like to come up and do the closing remarks. We do have a reception downstairs, a meet and greet for some of the other candidates that are here, and we have some refreshments.
Thank you. I want to acknowledge our panelists of judicial candidates once again. Thank you all. Let's acknowledge them. Thank you all so much for being here and just for your answers and just also for the time that we'll have in fellowship with you after this. I also want to acknowledge our moderator, Dr. Solomon. Thank you so much for just being here and for supporting us this evening. And I, of course, would like to acknowledge all of the members of our staff that helped to organize tonight's gathering and worked really hard and diligently to create this space. Of course, you saw Mina and Taria, and then, of course, we have Megan and Rashana in the back, and I think Damon greeted you all. And then, of course, we have our amazing interns. One is all the way in the back, helping to register for those who need to register for vote, and then of course helping Madama helping with Facebook Live. So even if we may not have a room full of people here, there are people who are watching online, and so we just want to thank each and every single one of you for coming out, and we look forward to our fellowship with you. And again, as has already been shared, if there are opportunities for us to partner and be in community with you in the future, we hope that you will visit us at communityrenewalsociety.org or connect with any member of our staff so that we can be in touch. Blessings and thank you. And remember to vote, and that's March 17th. March 17th, please, let's get the word out there. Let folks know that it's not just November that we're waiting on. There is an election next month, so please vote. Thank you all. Oh. Early voting, March 2nd through the 16th is available. Thank you for that. So let's get the word out, and the most important thing is for us to be engaged and to honor our civic duty and responsibility. Thank you.